Hi, it's Toronto immigration lawyer Max Chaudhary, and I want to discuss a common question that relates to applications for visas and other privileges under Canada's immigration laws. And that is, my application got refused. How long do I have to take that refusal to the court? The answer to this question sometimes is related to the location of the office that decided your application. Typically, if the officer or tribunal is inside of Canada, then you typically have 15 days to take that decision to a tribunal such as the Refugee Appeal Division in the case of refused refugees, or the federal court in this case of refused refugees who have been to the Refugee Appeal Division, or if there is a case of a refused humanitarian compassionate application within Canada. And again, if the application, for example, for a refused permanent resident application under humanitarian grounds is refused, then you have 15 days to take that decision to the federal court. In other situations, if the decision is rendered outside of Canada, for example, by a visa officer, then in those instances, oftentimes there is 60 days to take that decision to the federal court. Or in other cases, take that outside of Canada decision to the Immigration Appeal Division. Examples of this may include a residency obligation appeal, which is triggered by the refusal of an officer outside of Canada to issue a travel document for permanent resident card holders who are seeking to enter Canada. Similarly, a person who has received a refusal for visitor status outside of Canada, or for a study permit, or for a work permit, would have 60 days to take that decision to the Federal Court of Canada. A somewhat complex situation takes place when there is more than one refusal. For example, one refusal may lead a candidate who's rejected to file a request for reconsideration with the visa officer. And in some cases, the time limit may start all over again. In other cases, it may not. The key may, in some instances, relate to the substance of the second refusal issued by the officer. And in some cases, when there is more than one refusal arising from one application, legal advice may be required to determine when the due date is, and if appropriate, ask for an extension of time. If you're faced with a decision that is a refusal related to a visa or some other kind of privilege under Canada's immigration laws, contact Chaudhary Law Office. Thank you.